Okay, I see that we are 4 p.m. Hong Kong time, so we're ready to start, and I can see many attendees are already dialing in. So first off, just to introduce myself, I am Joanne Lau. I'm the Secretary General of the Hong Kong International Arbitration Center, the HKIAC. So it's a pleasure for me to be moderating today's webinar. Thank you everyone for taking the time to dial in for this webinar, which is jointly organized by the HKIAC and the Nairobi Center for International Arbitration, the NCIA. For me, I am particularly excited about this because today's webinar follows HKIAC's recent visit to Nairobi for the really fantastic Nairobi Arbitration Week, where we also collaborated with the NCIA. HKIAC and the NCIA have a very strong friendship, having signed an MOU back in 2023. So the theme that we are exploring today is resolving construction disputes, practices from Hong Kong and Kenya. And I am really honored to be joined by leading experts in this area from both Kenya and Hong Kong. So to start off, I will give a brief introduction of our speakers today. So first we have Ms. Mercy Okiro, who is the chairperson of the National Construction Authority in Kenya. Mercy is an advocate of the High Court of Kenya, a trained arbitrator and accredited mediator of the Chartered Institute of Arbitrators London and the Nairobi Center for International Arbitration. Mercy is also a construction adjudicator and adjunct faculty member at the Kenya School of Law and Strathmore University, and convener of the Law Society of Kenya Sports Disputes Tribunal Bar Bench Committee. She has sat on many local and international boards and committees, as well as on the panels of various institutions. And having met Mercy, I can testify personally that she is a very busy and very prominent member of the Kenyan dispute resolution community. Next, we have Ms. Barbara Adhoc, who is the CEO of the Association of Consulting Engineers of Kenya, the ACEK. Barbara is pivotal in developing and executing the organization's strategic plan that values innovation, sustainability, and social impact. Barbara has over 10 years of experience and background in civil engineering with a specialization in highway planning and design. She is passionate about delivering sustainable and efficient infrastructure solutions. And as the non-lawyer in this group, Barbara, I'm sure, will bring a lot of technical expertise that a lot of lawyers are really in need of in covering today's discussion. Next, Ms. May Ng. May is a partner at DLA Piper with over 20 years of experience in the legal industry. May's practice concentrates on construction dispute resolution, the drafting and negotiation of construction contracts, and commercial litigation. Her areas of focus include litigation, arbitration and investigations, construction, and engineering. May's clients range from large blue chip multinational companies to medium-sized enterprises. She regularly represents developers, contractors, engineers, suppliers, and manufacturers in construction claims. And she has handled major disputes and litigation involving a wide variety of construction and infrastructure projects, including shopping centers, residential buildings, office buildings, school, casinos, and hotels. And I know from May's profile that she has also done disputes involving African projects. And last but certainly not least, we have Timothy Hill. Tim is an international arbitration practitioner with Arbitra based in Hong Kong, with over 35 years of experience in commercial dispute resolution. So Tim transitioned into a full-time arbitrator role after serving many years as a partner at Hogan Lovells and as the former managing partner of its Hong Kong office. Tim's practice primarily focuses on the construction and engineering industry and has represented numerous parties and clients from the building and civil sectors, including residential and commercial development, hospitality, rail and transportation, and the energy sector. And I can personally also say that Timothy has contributed significantly to the development and work of HKIAC over the years as well. So I'm very grateful for all our esteemed panelists' time today. So what we have planned for this 1 hour webinar is that each speaker has prepared a very short presentation covering aspects of the theme that we are exploring. But at the same time, I see that we have over 200 attendees already dialed in. So I would very much welcome attendees to submit questions through, I think, the Q&A button or the chat button. Because we have allowed for time as well for the panelists to engage in a free flow discussion and to answer questions from participants at the end. So please keep the questions coming, and we would be very happy to keep this interactive. So without further ado, I think first off, I would like to invite Barbara first, perhaps, to provide us with the overview of the construction industry in Kenya. I think today's theme, when we look at practices from Hong Kong and Kenya, and I think one of the key participants in the region where Hong Kong is also, the Chinese contractors, Chinese investments, and obviously from China, there's also a lot of interest in construction infrastructure projects going on in Kenya. So I think with an overview at the start, that would set the scene nicely for today's discussion. So over to you, Barbara.
Thank you, Joanne. So I'll share my presentation. I hope you're able to see my screen. Okay, so I will just give a brief overview of the construction industry and just the projects in Kenya and try and also look at it from the East Africa region. One of the things that I'll be looking at is why we are looking at the industry or the sector as a vibrant sector and the growth that is being seen in this sector. So basically, the construction industry is one of those sectors that has embedded itself as a pillar of economic development. What we are seeing is that there's a correlation between the way when the construction industry performs in a certain way, how it will impact the economic development of any particular country. So Kenya and by large the East African region continues to see this growth over the course of time. And another thing that I can probably mention at this stage is the industry not only contributes to the GDP, but it's also a big employer, what we tend to refer to as the multiplier effect of certain investments when you make to the industry. Currently, in the financial year 2024-2025, the development expenditure that the government has set for development is at about 5.5 USD. And just to go more into the technical bit of this, that in 2015, there was a study by Frost and Sullivan, which was about opportunities in East Africa in the construction industry, which projected that the region will expand in value about 3 billion USD in the next 6 years. And this is due to increased investments. Looking at it, this was 2015. So by the year 2023, the Kenya Economic Survey released also some facts and figures, and they saw that the industry grew by 4.1% in 2022. There's a reason this will be particularly interesting, because this was a decline from 6.6% in 2021. But you would notice that this was the period where we were trying to recover from the COVID-19 shocks. Because in 2015, we had the industry at about 13.8%, the growth was about 13.8%, and the GDP value by then was at about 307 million. This was a time when we had the SGR Phase 1 and Phase 2. We had the first of the 3 berths of the Lamu Port that were completed. And therefore, the sector is going to maintain this growth, because now in the year 2023-2024, there's also a reduced government spending. in the infrastructure sector. And perhaps this will discuss at a later period. So now, based on all that I've said, what are these factors that are driving this industry? And is it something that will continue to see a vibrant growth as we continue? So what the governments, or basically as we continue seeing growth, what has come out clearly is that when you have properly designed, planned, and operated connectivity architectures, they're able to facilitate circulation of people, of goods, and of commerce. And therefore, if we already take cognizance of this, and then we also see what are the needs we have. Kenya is the seventh largest economy in Africa. We have an estimated GDP of about $113 billion. And then we're also the fourth largest economy. So there's a lot of attraction that the country has in terms of investment. And therefore, we have the government that is now being very deliberate, setting in terms of investing in infrastructure. We have the Vision 2030. This is a development program that was supposed to sustain this. Then we also look at it from the fact that we have a port, a major port in Mombasa, that also serves about 200 million people, not only in our corridor. This is Tanzania, Uganda, Rwanda, and the DRC. So over the course of time, we have different governments that are coming up with particular programs towards the agenda of economic development. We have, as mentioned, we have the Vision 2030. But over time, we also had the Big Four agenda. This was from 2017, 2022. We also had we currently have the Better agenda. These are specific strategies that are just going to still address the key challenges that are aimed to achieve the certain goals within the frameworks of development. The other thing that we are seeing is on urbanization and population growth. And again, East Africa region is seen as the fastest growing region in the continent. The average growth rate is at about 6.7%. And this was between the period of 2013 and 2017, according to UNEP. We have a rising middle class that have an increasing pressure which now brings an increasing pressure to have urban infrastructure. And one of the things I should mention that again, in terms of infrastructure, that the subsectors that are seen to be developing a lot is the transport and real estate. So on promulgation of the 2010 Constitution in Kenya, we not only now have the national government, but we also devolved governance. So we have the county governments as well. And this was to deter the issue of rural to urban migration, because there was a lot of that looking for job opportunities. So now again, with that, the fact that now we are containing people in different areas, there's also the different levels of government are also taking note that they will still need this infrastructure at these different levels. In the county areas as well, we have 47 counties currently. So again, there are efforts to alleviate the housing deficit, and not only that, they'll have to be accompanied with public works, which are again vital for development. We currently have the affordable housing. This is under the Better agenda that I had mentioned earlier. And then the third thing that we're also noting is that there's this issue of regional integration and connectivity. We have the EAC governments that have now a renewed commitment, because now we want to trade together as a region. And then we are ensuring again free movement of people, free movement of goods. And we have this particular project, it's called the LAPSET, which is the Lamu Port South Sudan Ethiopia Transport Corridor, one of the largest East Africa and most ambitious projects. So looking at all these three things coming into play, this is why we keep seeing that perhaps the region will continue, the sector will continue with the growth. And is it something that we are going to be doing alone? Or is it as countries, or are we going to be seeing other players coming into the picture? So now I just want to look at how we have international parties coming into play. Joanne, when you are doing the introduction, you mentioned the issue of Chinese investments into the region and also into the country. So infrastructure projects, yes, there's a very dire need of it, but what we also are aware of is they're very heavy in terms of financing. They require a lot of financing. And looking at it, then the region is also characterized with what we used to be calling developing countries. So now, according to the World Bank, we face, as a country, we already face a significant financing deficit. And this is an annual outlook of it. So this has also constrained the growth and development in the region and also in the country. We have sustained expenditures of about 4 billion per year, which are required to meet our infrastructure needs. This is the same characteristic with these nations that are in the region. And one of the key areas that we see now international parties coming into play is in terms of financing. I've listed a few projects which I would just like to bring into the picture just to show how the international development finance institutions come to the aid of our nations in terms of financing our projects. So of course, I've looked at it from the region. Now we have this project in Uganda. We also had funding in for the SGR. This is in Tanzania. We have the World Bank that came to finance the northern and western corridors in Kenya. And then we have the SGR. This was by the China Exim Bank, which was a loan. We also have projects in Entebbe and the seaport of Mombasa. Then I also looked at one of the things that, yes, we are relying on loans, but in the growing wake of government debt, which has also been a concern, especially in our country, because now we have an overall debt to GDP ratio standing close to 70%. And it means that the level of debt has reached the country's ceiling for borrowing. And also the issue of debt servicing is has now become a talk in terms of the national budget. So with these growing concerns over this debt distress, there was a need to shift from initially from concessional loans to commercial loans, but also consider other avenues to finance the infrastructure needs. And this is what now led to this bringing the private sectors into play through what we're calling the PPPs. And I'm not saying this is the only other avenue, but I was just trying to look at it. How have we now seen other parties come into play? The first one is, of course, the approval of our 27-kilometer Nairobi Expressway. And this is one of transport landmark in the country, and was through a private partnership between KENHA, this is our National Highway Authority, and the China Roads and Bridge Corporation, CRBC. It is also the intention of the government to continue with such investments because now we have the Nairobi-Mombasa Expressway. We also have things in the pipeline, including Nairobi-Nakuru Summit Highway, and these are all planned through the PPP model. I'd mentioned the project LAPSET, and there are 29 berths to go. These are also being considered to be financed by the private sector. So we've talked about financing, we've talked about the other avenues of financing, but we're also seeing professionals who are coming into the country or into the region throughout the implementation of works also as players in the industry. And yes, we do boast professionals in the AEC field. This is the architecture, engineering, and construction field. But now, first of all, because now we had loans to help us in the infrastructure development, some come with grant conditions, and now we have to rely on personnel from where we are borrowing from to implement the project. But not that alone, because we also have advanced projects, looking at the ambition we have in terms of development, in terms of the projects we are undertaking. We have technology and high infrastructural standards, and in some cases, we are not able to source for this in the country. Then we are seeing contractors, consultants who are coming from outside the country. Some of them that I've listed included, again, CRBC in the Nairobi Expressway. We had Atkins Global to do the design of the Nairobi Railway Transit. And again, the issue of Chinese contracting firms, very heavy in Kenya, doing much of the contracting of the projects that are currently in the country. And particularly now, if we delve into the discussion of Chinese investments in Kenyan projects, this Look East policy is something that started way back. We saw it from the presidency of Daniel Moi. This is from 1978. We saw it with Uhuru Kenyatta, and it's currently something that's ongoing. So Chinese being in the country is something that continues to be a trend. And the relations, of course, go through various fields. We have trade, we have information, we have military, but what normally ends up being very prominent is in the mega projects that that are Chinese sponsored. So of course, it started with the approval of the 50-kilometer Thika Superhighway. This is all the way back in 2007. But other flagship projects that we've seen involvement from China includes the SGR, which I think I've talked about it a couple of times before. This was by a CRBC loan from the China Exim Bank, constructed by CRBC, but the loan was from China Exim Bank. Again, we have the LAPSET, also funded by the Chinese government, which was funded by the Chinese government. We have the SGR, also from the Chinese Exim Bank. We have, I've mentioned the issue of LAPSET and, sorry, I'm having a bit of an issue here, but we should be able to continue. And then also in 2024, there were reports that the Chinese African Development Bank is still going to be doing a lot of funding in road infrastructure. I'm sorry for the engineers who may be on the call that I seem to be dwelling a lot on the transport sector, but I think this is my area and I don't want to talk so much more on things that I may not I will perhaps have more of my reference towards the transport field. There was a state visit by the president again in 2025 to China, which now also renewed a couple of further projects that we have. Now, on issues of why we are here, as mentioned, it's to do with dispute resolutions, and we are looking at why disputes are rising, and in the construction sector particularly, because one of the things that, of course, there was the notion that it's very common to have disputes in the construction sector. We could look at it from the fact that you have a lot of personnel that are handling various phases of the projects. And then the other issue is that when disputes arise in the construction sector, they end up being very costly. We have to look at the interaction. We have the client, we have the contractor, we have the consultant, we have the suppliers, both for material and equipment. And in such a case, because everyone is interacting and speaking their own language, there's a very high chance that there will be a dispute that will arise. So if you look at it in terms of why the disputes will be arising, I've tried to categorize it in just a brief. We have when disputes would arise due to contractual and legal issues. How are we drafting our contracts? Are we very clear on such items that we've stipulated over there? How are we allocating our risks on issues to do with delays, force majeure, land acquisition, and also just on the reality of the cost or the time estimations during the tender and the design stage. We also have disputes when they arise due to payment and related disputes. We also have issues to do with design and documentation challenges. This is to do just with things to do with late approval or revision of drawings. Are our designs that we are providing complete, and are they communicating? Or issues just to do with how, when we change the design, of course, there may be instances where you have to do it, but what is the frequency? So such items do lead to disputes. And then we also have planning and management weakness to do with scheduling or coordination, site supervision, or even execution. Are we now having the contractor go back to site due to unclear instructions? Again, communication and coordination failures also seen as one of the issues that leads to disputes, where we have gaps in the communication among projects. And as I'd mentioned, we have a very multidisciplinary team. So things to do with communication tend to bring issues now and again. Do we have delayed decisions, or are we prompt in giving feedback, or even just misalignment on scope, deliverables, or even quality expectations? We have the issue of resource and supply chain constraint. due to late delivery of materials and equipment? Are we doing mid-project substitutions, or even just the shortage of skilled labor and even unskilled labor or breakdown of machinery? And finally, something else that I saw would lead to disputes would be quality of workmanship issues, in use of inappropriate, outdated construction methods, and even defective work or substandard materials, and incompetent contractors, or even just the subcontractors that we are utilizing. But all in all, this I think will be further dealt with with the other panelists. I think, John, I'll bring it back to you because that will be my presentation. Thank you.
Thank you very much, Barbara, for that very comprehensive overview. For me, I'm very excited to see that there are so many ongoing projects, including in transport and other sectors happening in Kenya and across East Africa. And I think we can tell from that overview just now that there is a very high demand for financial resources and funding those projects, also technical expertise, relying on a lot of engineers. But at the same time, as Barbara highlighted, whenever there are projects, there will also be issues to resolve, potential disputes. That is part of life. So there will also be a huge demand for legal expertise. So I think this is a good point for us to turn to May. Perhaps May can provide us with an overview of what Hong Kong can offer in terms of legal expertise when handling projects in the construction sector.
I hope my screen is working okay.
Yeah.
In terms of the slides to get it on screen. So I thought I should just start with a very quick background of the history of arbitration development in Hong Kong. Actually, I tried to do a bit of research to find out when was the first arbitration that had taken place in Hong Kong, and it turns out from my search on the internet, I think it was back in 1843. So that was quite some time ago, even before the British ruling of Hong Kong. And for the recent times, actually, construction disputes have actually shaped pretty much the arbitration practice in Hong Kong, because since the enactment of the arbitration ordinance in 1963, I think constructions has been leading the way in terms of using arbitration as dispute resolution mechanism. The standard form of contracts in Hong Kong dated back to the 1960s and 70s have already provided for arbitration as the dispute resolution mechanism. So we do have a very long history of resolving disputes through arbitration. So very quickly on the arbitration law in Hong Kong, in its earlier form, we have a distinction between the domestic arbitration and international arbitration, where the international arbitration section is mainly modeled on UNCITRAL model law, the 1985 version, whereas domestic arbitration is based on the English Arbitration Act regime. And then in 2011, we have a major reform of our arbitration ordinance, which combined the two regimes of domestic and international arbitration, and extending the application of the UNCITRAL model law to all arbitrations in Hong Kong. And then later on, third-party funding was introduced alongside with outcome-related fee structures. And also in 2021, there is an amendment to the ordinance providing that all arbitral awards made in the PRC in the mainland China will be enforceable in Hong Kong. And a party who has a PRC arbitration award will also be able to simultaneously enforce that in both Hong Kong and the mainland China. I think having talked about the reciprocal enforcement and simultaneous enforcement in two jurisdictions, it may be helpful to just have a brief explanation about the legal system of Hong Kong in case some of the audience are not familiar with the situation in Hong Kong post-handover to mainland China. Now, the legal system in Hong Kong, it's largely a common law-based system, and it is a completely separate and distinct system from the PRC judicial system, despite the handover of Hong Kong back to China. Under the basic law, which is the Constitution of Hong Kong, we have this principle of one country, two systems. While the mainland China is based on the socialism and Hong Kong is on the capitalism system, the legal system is also being kept distinct from each other. So Hong Kong, it's still applying common law, whereas China, it's on a civil law basis. So the two judicial systems are completely separate and distinct from each other, but we have in place arrangement for reciprocal enforcement of judgment between PRC mainland and Hong Kong. And there is also separate interim measures, court-assisted regime, where I think Timothy is going to go through that in the latter part of the session, so I'm not going to go into detail. But I thought it is important to just let everyone know a little bit more about the legal system in Hong Kong being a distinct and separate system from mainland China. So in terms of Hong Kong's expertise and advantage in arbitration, given the British ruling and also a lot of construction projects disputes being resolved in arbitration, we do have a wealth of arbitration practitioner, advocates, and arbitrators working in Hong Kong since the early 80s in the Airport Call program. So we have a very mature and well-developed arbitration practice here in Hong Kong. And in Hong Kong, international parties can pick Hong Kong as a neutral seat and can adopt the Hong Kong IC administered rules for cross-border arbitration. This is particularly popular in terms of the neutrality, where you have parties from different parts of the world or projects outside of Hong Kong, but choosing Hong Kong as a neutral venue, given its common law background and also a very well-developed and mature arbitration practice in Hong Kong. Domestically in Hong Kong, most of the construction projects, when they have disputes, they will be resolved by arbitration, adopting the domestic rules of Hong Kong IC. It's a light touch approach as compared to the normal administered arbitration. But parties are actually in Hong Kong, they are free to choose to conduct their arbitration on ad hoc basis or institutional based, depending on the place where the arbitral award is going to be enforced in. For purely domestic projects, they are mostly done on an ad hoc basis. Now, I have touched upon third party and outcome related fee structures as part of the Hong Kong's advantage in arbitration. They do allow parties to manage their costs and risk more flexibly. And I've also touched upon Hong Kong being a very safe and reputable seat. I'm sure Joanna can provide you all with more statistics about arbitrations in Hong Kong. And the Hong Kong government has been promoting Hong Kong as an arbitration hub and a legal dispute resolution center. So there are lots of policy-driven initiatives to build Hong Kong or to position Hong Kong as the leading arbitration hub, especially in Asia. And the Hong Kong court has also set up a specialist construction and arbitration list to handle applications that are related to arbitration ordinance or matters such as interim measures requiring court's assistance and intervention. And courts in Hong Kong is generally very pro-arbitration. They will uphold arbitration agreements between parties. And very often where parties have entered into arbitration agreement and try to actually litigate in court, the court has almost always very readily grant stay of proceedings in favor of arbitration, as long as there is a primary facie case of existence of an arbitration agreement. Basically, once the applicant has discharged their duty, the stay will be granted, even though there may be issues about admissibility or jurisdiction. These matters will be left to be decided by the arbitral tribunal rather than by the court. And I've mentioned a few times interim measures in aid of arbitration. There is also a specific provision in our arbitration ordinance allowing courts to grant interim measures in relation to any arbitration proceedings which are commenced inside or outside of Hong Kong, or arbitrations which are yet to be commenced. You are still able to obtain interim measures, providing the criteria set by the court are met. Now, I was going to touch upon common construction disputes in construction projects, but I do notice that Barbara has already touched upon different causes of construction disputes. So I'm conscious of the time, so I will just skip this section so that other speakers have more time to go through their presentation. One last thing that I do want to mention is that Hong Kong is going to introduce adjudication in the end of August. It will become compulsory for projects or contracts enter into after 28th of August. So that is potentially going to change the dynamics a little bit, but I think we can talk about it more in the Q&A session. So handing over to you, Joanna.
Thank you, May, for that very clear outline of strengths of Hong Kong, and also doing some research, going back to the history of arbitration. I think for a lot of people, when you think of Hong Kong, you think of financial hub, commercial hub. Lots of people don't realize this. It also has such a deep-seated pool of construction specialists, and even just looking at the name of our specialist list, the construction and arbitration list, you can see that over the years, both the construction industry together with arbitration expertise have almost developed together hand in hand. So a lot of the arbitration lawyers in Hong Kong actually started out doing a lot of construction disputes. So thank you for bringing out that point. On my part, perhaps let me also share a little bit of statistics from HKIAC side. Let me see if I can do that. Yep, hopefully people can see that. Just to illustrate the point that I was talking about, so construction disputes actually do take up quite a significant portion of HKIAC's caseload every year. What I've shown on the slide now is our statistics from last year, 2024, where we had a record-breaking caseload of 352 arbitrations arising from over 500 different contracts. You can see from this slide that construction disputes appear in the top 5 sectors of the cases that we received last year, and this is pretty consistent in that in the past 5-10 years, construction is always a popular sector contributing to our cases. There is some overlap between the different categories as shown here. For example, where you see commercial disputes, some of them are shareholder joint venture disputes, which could also arise in construction infrastructure projects, or some of the financial disputes, financing disputes could also arise in construction industries. So really, this is to illustrate that there's quite a heavy proportion of construction disputes in Hong Kong. Turning to the next slide, for our cases from 2024, it is very international in nature, in that over 86% of our administered cases are international in nature, with at least one party coming from outside of Hong Kong. Hong Kong and mainland China are our top two parties in our caseload. Mainland Chinese parties usually appear in around 40% of HKIAC cases. So a sizable proportion, but still quite a lot of cases without Chinese element as well. And for this webinar, I also wanted to share some Africa-related statistics. So you can see from 2019 to 2024, HKIAC had 62 different cases involving African parties. 22 were African parties on claimant side, 52 were on respondent side, and for those good in maths, you can see this also means that for some cases, there are African parties on both sides. And if we look at statistics from the past 5 years, we had 44 cases with African parties. In terms of governing law, the most popular one is Hong Kong law. Over 40% chose Hong Kong law. This is followed by English law. Around 30% of those cases picked English law. And the third place, although with a bit more far behind, is Seychelles law. And as for seat of arbitration, as May talked about just now, Hong Kong is a popular seat of arbitration with very pro-arbitration courts, and Hong Kong is the most popular seat of arbitration in our Africa-related cases, around 91%. And the HKIAC administered arbitration rules are also the most popular applicable rules in those cases. We often get questions as well as to whether we have African arbitrators on our panel or list of arbitrators. For parties, they are not confined to our panel and list of arbitrators, so they are free to pick candidates from outside HKIAC panel and list. But parties often look at those lists for reference, and we do have 2 Kenyan arbitrators on our panel and list of arbitrators, and we hope to see more. So for those Kenyan arbitrators who are online today, please feel free to submit applications to our panel and list. And other nationalities from Africa on our panel and list of arbitrators include arbitrators from Egypt, Mauritius, Nigeria, South Africa, and Tunisia. In 2024, HKIAC made 199 arbitrator appointments and 220 arbitrator confirmations. And this also includes 3 appointments of arbitrators of Kenyan nationality. So with that, an outline of what HKIAC has been seeing from an institutional perspective. And at this juncture, I want to hand over to Mercy to also share her observations as to the dispute resolution methods that she has seen chosen by African parties. And as you can tell from the introduction, Mercy wears multiple hats. Arbitrator, mediator, construction adjudicator. So looking forward to your sharing. Mercy, over to you.
Thank you so much, Joanne, and thank you, HKIAC and NCI for inviting me to this webinar. I'd like to correct some policy statements because I chair the National Construction Authority Board, and perhaps the thought around Chinese contractors and the 2002 to 2012, let's say, government, at the time we lacked expertise by local contractors. So, of course, China having been ahead of us in the construction space, we had, of course, to get them on board. But I give my reassurances that we are now, of course, really following up on the real intention of having foreign contractors, which is skills transfer. And I can confirm that our affordable housing program, which is a government flagship program, which is getting allocations of up to 150 billion per year, is definitely comprehensively done by local contractors only. So as the regulator, of course, we're looking to have proper skills transfer by the foreign contractors, and you're correct, as per Barbara, most of them are from China or they're Chinese contractors. Now, on the dispute resolution methods that are used essentially in construction disputes in Africa, you find that we have a gap actually in data collection in this area of dispute resolution. So that I will not be able to speak for the NCIA as much as we work together, except to say that the data really is more or less similar, because even if you look at one of the most recent studies in 2022, the SOAS AAA Africa study on construction and general dispute resolution in that sector in Africa, at the end of the day, you'll find that mediation, of course, still is there, 19.4%, construction adjudication dispute boards at 15.5%, and arbitration at 36%, litigation at about 14.6%. So that you find most of the disputes, either way, they will go to DABs or arbitration. For litigation, of course, generally there's been a move away from using litigation because, as has been said by Barbara, of course, the common themes in construction disputes are delays, extensions of time, force majeure also, of course, post-COVID, that also became a turning point in many disputes. And of course, you have wrongful terminations, and that now speaks also to the African way of doing things, if I may say so, where a lot of contracts also are linked to a person in terms of when a new administration comes in, perhaps they want to terminate some contracts, etc. But then also we have an issue with delays where instead of following the dispute resolution procedures, you find that some employers opt for termination. The Kenyan situation is the same. You'll find still, because here in Kenya, we do not have a Construction Adjudication Act per se, though I keep saying national, but the Nairobi Center for International Arbitration has recently, we were actually doing public participation on what we hope to be the Construction Adjudication Act, because currently what happens is that the disputes that arise in this industry, the dispute resolution process is contractual, and the most adopted, of course, standard form contracts are usually FIDIC, and of course, I'll say JCT, the Joint Construction Handbook, the Green Book. And in those, you find that FIDIC is more preferred because also the mega construction projects have, of course, a lot of more money involved. So that in there, of course, there's a mandatory requirement now for arbitration, and the dispute resolution clauses there are clearer. So that now in Kenya, even without the proper data that we've said in terms of research has been done, you'll find there's a DAB, which are now actually becoming very popular, the dispute avoidance boards, dispute adjudication boards generally. They're becoming more popular. And of course, the culmination then becomes arbitration. There's a decision, I forget but I'll type it in the chat, just recently, where courts in Kenya actually have demonstrated that wherever there's an arbitration clause, that is a position in Kenyan law anyway. Even if it's a construction contract, the court will always uphold the terms of the contract, where arbitration would be the preferred method. Of course, ICSID in 2024 also has released data on the disputes. And of course, we see increasingly now 18% are infrastructure and construction projects related disputes and claims, again, with an increase of 12% from sub-Saharan Africa, because currently Africa is one big construction site. Kenya is also one big construction site. So that, as Barbara correctly stated, there's a lot of construction happening in sub-Saharan Africa. And even then, we still have challenges sometimes in terms of expertise, in terms of the projects we want to undertake. Sometimes also one of the conditions of the funding is that we have representatives or consultants, as it were, of the person who's either giving the grant or the loan. So that as a result, there'll be a dispute, and you find now this dispute will have two states. And in the case of China, Kenya, you find that most of our contracts will have, I know this is not desirable for the Kenyan population, we'll have a CTAC clause, and the arbitrations are seated in China. Then, of course, I believe NCIA can speak to it more. We had the China-Africa Joint Arbitration Center, which is a MOU signed between Shenzhen, I think, International Arbitration Center, and the NCIA. But then now we have the HKIAC NCIA. What I'll say is that in terms of construction disputes proper, we hope that when our act, when the bill is, of course, discussed and all the processes are undertaken and we have an act, that will cement the place of construction adjudication in Kenya, because arbitration is more or less, right now, it's acceptable. more importantly, of course, now with that partnership of HKAC and NCIA, we really hope that we can collaborate in terms of learning construction adjudication proper in terms of training, because currently the training is only done by SIAB, and even then, not many people have been taking it seriously. But then now I believe the angle of HKAC would also be good, because most of these international disputes relating to construction will most generally or most probably involve China. And of course, it would be good for us to also have that cooperation. The other thing perhaps I'd say is the issue of expert witnesses. And on this one, studies have shown, even the few studies that have gone through, is that we still find ourselves here in Africa and even in Kenya, when we have international disputes around construction, we still rely on technical experts from beyond the continent. And perhaps now that then speaks to, outside of just understanding construction adjudication, outside of understanding arbitration, do we have capacity building? And perhaps this is one of the areas of cooperation on expert witnesses, because of course HKAC has more expertise in that. And then we see if we can build capacity, because the construction is ongoing right now. Even in Nairobi, everyone is constructing, and across the country. So that we need to also move with speed so that we have that, and also borrow a bit around technology and use of technology in resolving these disputes. Yeah. So I'll say that would be my overview on the methods. Thank you.
Thank you, Mercy. And I completely share your view as well, that there is a lot of room for collaboration between HKIAC and other dispute resolution bodies in Africa, particularly on capacity building, and your observation in relation to the need for more expert witnesses and qualified expert witnesses in this area. I think that is also shared by many. So we hope to do more in the future. Last but not least, I want to turn to Tim now, because both Barbara, Mercy, everyone basically mentioned a lot of Chinese African collaboration on projects in Africa. And I'd like to see if you can share some of your perspectives in relation to what Hong Kong can bring, like the unique advantages in choosing Hong Kong, I guess, particularly when it comes to a dispute with the China element. Over to you, Tim.
Joanne, thank you very much. I hope everybody can hear me clearly. Good morning to everybody, and good afternoon as well to those of you that are in the afternoon. I have just a few points that I wanted to raise. May has already made reference to the one country, two systems arrangements, which means effectively that although Hong Kong is part of China, it has, to a large extent, an entirely separate legal system. One of the particular matters which is relevant to arbitration is that arrangements have been made with the courts in the mainland of China for interim measures of protection. And this is a unique feature of the Hong Kong environment. Now, we have seen 157 applications with a total value of some US $5 billion. And we see that this provision is being enforced and given effect in the mainland. Now, there are a few requirements associated with this. The first is that the dispute is a commercial one. It doesn't apply to investor-state arbitrations. And secondly, as far as Hong Kong is concerned, the arbitration must be seated in Hong Kong and administered by one of a number of institutions. Now, the HKIAC is one of those institutions, and its administered arbitration rules are very much a light touch in comparison to those perhaps of the ICC or other institutions that you may be familiar with. And the HKIAC, I think, knows the outcome of 95 cases, and the mainland courts acted promptly making orders within 27.9 days. And you will find that the HKIAC will assist parties in the requirements to comply with those. I've provided on this site links to a couple of websites which will provide helpful information in relation to such applications. The next area I want to just touch upon briefly is the question of enforcement of awards. China is a signatory to the New York Convention. In relation to the mainland itself, there is a reciprocity requirement, which would not be an issue in relation to Kenya, because Kenya is also signatory to the New York Convention. There is no reciprocity requirement in relation to Hong Kong. Hong Kong has a very simple mechanism to enforce arbitration awards. Effectively, an application is made ex parte, and the court will, on the basis of the papers, make an order to permit an arbitration to be enforced in the same way as a judgment, subject to the right of the respondent to apply to set aside that order. It is a pro-arbitration seat, so it is quite rare for enforcement of awards to be refused, and is based on the New York Convention. Generally, Hong Kong recognizes that arbitration is an international vehicle. So when it comes to the interpretation of our ordinance, which is based on the model law, the international route is recognized. Authorities from other model law jurisdictions will be referenced by the court when they are considering enforcement. Like Hong Kong, in the mainland, only the grounds set out in the New York Convention will be relied upon for the purposes of refusing enforcement. The mainland is generally a pro-arbitration jurisdiction, and in order to restrict the non-enforcement of awards, the Supreme People's Court has put in place a mechanism by which a court that is proposing not to enforce an arbitration award must report to the Supreme People's Court before refusing enforcement. Now, I wanted very briefly in my final slide to make a reference to a few common challenges. It does seem to me that in many cases, emerging from Africa, emerging from Hong Kong and Asia, there are cultural perceptions that perhaps Western European and Northern American arbitrators don't necessarily understand. The way in which business people will respond to situations, their willingness to be conciliatory perhaps in statements that they make. And so therefore there is an attraction to having arbitrators and people involved in the arbitral process that have an understanding of cultural perceptions outside of the way in which perhaps an American or a European would conduct themselves. Certainly my own experience of references from Africa is that there are business practices which are perhaps not the same as would take place in the US or in England and Wales. And that is true also of Asian business practices. And arbitrators need to be aware of the differences in different jurisdictions. I note that we've now run out of time, so I'm going to close there to leave a bit of time for some questions and answers. I've seen that we've got a few in the Q&A slot, but I'd be happy to answer any further questions.
Thank you very much, Tim, and thank you for sharing the mainland Hong Kong interim measures arrangement. I think for those dialing in who may be less familiar with Hong Kong, if you have one takeaway point from this webinar as to what is Hong Kong or HKIC's unique advantage when it comes to China-related transaction and disputes, the interim measures arrangement is something to really bear in mind. And the reason is for mainland China, unlike some other jurisdictions, there is no mechanism for Chinese courts to enforce a tribunal-issued interim measure, or for the so in other words, if say you're in a dispute with a party with assets in mainland China, there is usually no mechanism for you to freeze assets in mainland China for the duration of your arbitration. And the only possibility for you to be able to do that is if you have a Hong Kong seated arbitration and administered by a list of arbitral institutions, including the HKIAC being the most experienced institution. And if you have that arbitration, HKIAC, Hong Kong seated, then you are able to rely on that arrangement to make an application to mainland Chinese courts to seek to freeze assets in mainland China. And I think the important point that Tim brought out in the statistics is that this arrangement is not simply an arrangement which exists on paper. In practice, HKIAC has processed and issued letters of acceptances in over 150 applications. And in practice, we have seen mainland Chinese courts issuing asset preservation orders in support of Hong Kong seated HKIAC administered arbitrations. So whenever you have a contract with a mainland Chinese nexus, potential assets in mainland China, which you might want to preserve, then HKIAC and Hong Kong seat would give you a very unique advantage. So thank you, Tim, for...
Thank you. Joanne, I just wonder whether I might just add, because Mercy made reference to CTAC arbitrations and the use of CTAC as a seat. Hong Kong does perhaps offer an interesting alternative in the sense that it is obviously part of China, but it is a separate legal system. In terms of arbitration, advocates from any jurisdiction, and indeed non-lawyers, can appear in arbitration without any difficulty. And the panels of institutions like the HKIAC have a wide range of experienced arbitrators on them, drawn from a wide variety of different jurisdictions. Many of those arbitrators are very familiar with dealing with disputes involving Chinese parties and international parties. So they do offer, I think, to African parties an interesting alternative to CTAC or perhaps some of the other international institutions that the parties have traditionally referred disputes to.
Thank you, Tim, for that additional comment. I see that we do have a few questions in the chat box. I know a couple have been answered already. If we have 2 more minutes, I'm testing the patience of our attendees, but would anyone want to address any of them briefly?
Well, I was interested to pick up on the question about how people move into the field of arbitration, because I was pleased to see that Kenya has an active branch of the Chartered Institute of Arbitrators. Hong Kong proudly, I think, has the largest branch of the Hong Kong Institute, sorry, the Chartered Institute of Arbitrators. It has also a Hong Kong Institute of Arbitrators. And I would say to somebody who's interested in arbitration, go along to meetings of the Chartered Institute, meet people there, try and get involved in arbitrations in your business environment so that you get to know the process and procedures.
And if I could supplement on Tim's point of entering construction arbitration field, very often, not only are our arbitrators on the Hong Kong IC panel coming from a wide, diverse background, including engineers, architects, lawyers, quantity surveyors, there is also opportunities for acting as experts in arbitration as well, because very often in construction disputes, there are technical issues requiring expert evidence on. So people from the construction industry are actually quite well placed acting as expert. But I completely echo Tim's point about joining courses or activities run by the Chartered Institute of Arbitrators, or even by various arbitration centers. They may have training for arbitrators or adjudicators. Those are very good background learning, whether you want to develop a practice as an arbitrator or as an expert in arbitration, giving technical evidence.
Joanne, just to add to what Tim and May have said on this, if I believe the person who asked that question is most probably, based on the names, probably based here in Kenya. We have the BORACS, the Board of Registration of Architects and Quantity Surveyors. They have an arbitration panel. It's easier, I'd say, instead of, because mainstream arbitration in Kenya is usually overpopulated, or rather it's mostly advocates and lawyers. You really don't have to be an advocate. You have many, I'll say, prominent arbitrators who come from the construction industry. And also if you go to the BORACS offices, you can ask to be attached to one of the matters. And also in your day-to-day, you realize now that you understand there's this, you can look out for the contracts that are being executed even at your place of work, and just request that the person, in case there's a dispute, unfortunately, but fortunately for you, if you can be attached to learn, because from the construction industry, you have the advantage of being an expert in the field of construction as is. So even as you do the work in terms of exams, etc., as Tim has said, SIAB or NCIA, as the case may be, you are likely to get hands-on experience in your day-to-day, because there are really a lot of construction-related disputes, and those are the people really that are in your industry. Thank you.
Thank you, everyone, for those insights. And I see that there are still a couple of questions, including in relation to requests of statistics. So perhaps after this webinar, we can follow up on those requests separately by email. Conscious of time, let me just thank all our panelists again for joining us, and also all our participants for dialing in and for submitting the many questions. I think the key takeaway from today's webinar is that there are lots of opportunities, lots of projects, construction projects, which are still going on, happening in Kenya and across East Africa and wider the African continent, with Mercy's words, it being one big construction site right now. And there's a lot of room for further collaboration, and a lot of areas where legal experts, including in particular Hong Kong arbitration experts, lawyers, arbitrators, who can contribute to those areas. So I certainly look forward to a lot more cooperation and collaboration in the future. So thank you again, and hope to see everyone again soon. Bye.
Thank you. Bye.
Thank you.
Thank you.